Is Pet Pro. Well, Paul, did you kick papers out of her hand? No, he did that to you, didn't you? Blame him.
Speak at the door. I can't.
Okay.
George Valentine, hearing on behalf of.
Good afternoon, Ellie Kirsten on behalf of defendant.
And you two were here last week, and I do appreciate you agreeing to the adjournment. It was a day. So, and also I didn't have the stuff, but I was more than willing to hear you, but I appreciate the way you handled that. All right. I'll let whoever start with their argument first.
I think our bench memorandum really does address some matters and dispose of some matters, but the first issue, I know we laid it out in our bench memo. The first issue that I have to resolve is there was a question about the timeline of when our notice to terminate and the default related to the Section 7 inventory violation applied. There was some discussion that it happened within a less than a 30-day period, but that was not accurate. We had sent a notice back on April 28th, and then we sent a follow-up notice for the default on May 18th. And then the actual notice of termination didn't go out until June 16th. So there was far more than 30 days for that particular default for Section 7. So I think that kind of takes that issue off, unless the court has questions on that timeline. But
was that a defect that wasn't cured?
Correct, Your Honor. Both were separate bases that were noted in the notice of termination on June 16th. So we sent a notice on March 24th, which was with regard to the late fees. Then the defendants made a partial payment of the total that was being requested. We sent a follow-up response letter.
Well, let me just stop you there for a moment. Are you saying they made a partial payment of the total amount, or the partial payment reflects what these particular individuals would have owed?
Partial payment of the total amount owed by the defendants. So the total amount owed for the late fees owed by the defendants, they made a partial payment. There was still an outstanding balance of late fees. We responded with a follow-up letter indicating that it was not cured because there was still a remaining balance of late fees that remained due and owing. And around that same time, quite literally days later, on April 28th, we sent a separate notice of default for the Section 7 violation with regard to the inventory issues. We then, and I don't want to bore the court with a lot of reasoning for why we sent additional letters, but we sent additional letters because of confusion about whether the defendants were actually going to be represented by Dickinson Wright, and some emails between Dickinson Wright and myself that led us to believe that they might not. And so we sent additional notices directly to defendants to make sure we were dotting our I's on sending out the notice that was required. Regardless, we get to June 16th, far more than 30 days on the late fees that remained and on the Section 7 violation. And so we issued the notice of termination on that date. That is where the notice of termination included, attached to it, a demand for non-payment. And Your Honor had questions about why we would have attached the demand for non-payment. The reason being is that we were concerned that Pet Pros would try to take the stance that the late fees under the lease would be read as being part of the base rent. The lease didn't do a very clean job explaining that. And the timeline for filing or for asking for a demand for cure under the lease for that piece was a 7-day. So we erred on the side of caution when we gave the notice of default for 30. And then we also added with the notice of termination a demand for non-payment of rent in case Pet Pros took that stance. We now know, since they've filed their answer, that they don't interpret the late fees as falling under the base rent as it's defined under the lease. And we agree that that's the stance to take, but we wanted to give them their full 30 days notice under the notice of default And then to make sure that they understood that we weren't just filing this complaint as a notice of termination, but if they interpreted the lease as being something where late fees operated as base rent, it would be under the 600-57141A claim. Since we've come before your court, it's my understanding that you've since dismissed the 1A claim. But there still is the issue of after the notice of termination went out and the notice of termination indicated this, there was also an issue of the June late fee. That remains unpaid to this date. And that total specifically is $1,021.23. It's a simple calculation of 10% of the monthly rent due and owing. So we still have an outstanding late fee of over $1,000, and we still have the issue of the failure to cure the Section 7 violations that also resulted from the notice of termination as well. We've cited to case law within our bench memorandum, but I also want to emphasize that the Michigan Landlord Bench book bench brief makes it clear that there isn't a 30-day or 7-day requirement under the statute. Specifically, we cite to sections 5.1 and 5.7 of the bench book, but I also want to emphasize section 4.2, which more clearly explains it. Citing to section 600-57141C1, which is the power to terminate provision that we still maintain provides the court with standing. It states that while there's no statutory requirement for notice under this section, the notice requirement should be contained in the lease itself, and that a power to terminate the lease includes it has to have a clear indication of what action or omission by the tenant permits the landlord to elect such a remedy, and the lease must specify the notice of termination to which the tenant is entitled. The notice of termination clearly indicated that it was invoking the failure to pay late fees, that the 30 days had been expired, and the 30 days had expired on section 7 as well for the inventory issues. So when it comes to compliance within the lease and within section 1C1 for the power to terminate provision, that is what gives the court the standing to allow that matter to stand.
Okay.
And then finally, Your Honor, to address the issue of Park Forest, we have cited to Aspen, which very clearly explains that the way that Park Forest is read is that it is a may. That is that the court explains that generally speaking.
I'm going to tell you, I've litigated before I hit the bench Park Forest. I've ruled on Park Forest. I get what Park Forest and Aspen and the subsequent cases mean. The real question is are we going to have a hearing on whether or not the actions of the plaintiff would have reasonably led, and the court would have to make a finding, whether it reasonably led the defendants to believe that the lease was continuing. So I get how it's read.
Yes, Your Honor.
You don't have to go through that.
And that would be our stance, Your Honor, that at minimum, that it's a question of fact issue that can be determined by the court. We could have a hearing on that, but we would establish that not only under the notice of default, the notice of terminations that went out, as well as subsequent emails that I sent to opposing counsel as we led up to the first hearing date, which was June 10th, and certainly the hearings after that, that it's been made clear that there wasn't a waiver and that the section 21E further provides clarity that defendants would not have interpreted it that way. Thank you, Your Honor.
Bonds.
Good afternoon. I also believe that we set forth our argument in the bench brief, but just to touch on a few of the points that plaintiff brought up. First, defendant would assert that plaintiff asserts that they terminated the lease as of April 23rd, 2026. Based on plaintiff's date of termination, that would render defendant now to be a holdover tenant, creating an estate at sufferance, which would require 30-day notice under Michigan law. Defendant or plaintiff has continued to accept rent after the date that termination that they purport the lease was terminated. Defendant has continued to occupy the premises, and plaintiff has accepted rent and has failed to provide the 30-day notice that would be required to terminate, to give this court jurisdiction over summary proceedings for termination of an estate at sufferance.
What date are you saying they should have? What date are you saying they filed the notice to terminate?
Your Honor, it is our position that they filed the notice to terminate on June 16th, 2026. And the reason for that is, while plaintiff pointed out that there had been prior correspondence in earlier letters, those letters did not indicate that they were terminating the tenancy. They indicated that they believed that there were breaches to the lease, and that if those breaches were not cured, they may exercise the full scope of their remedies, which could include termination. However, no communication prior to June 16th indicated that the tenancy was terminated.
You believe that the tenancy can be terminated prior to judicial intervention? I mean, for your argument to work, that would have to happen, right?
Under the lease, yes, that the tenancy could be terminated pursuant to the lease if they provided the proper notice.
But I guess my question is it terminated without judicial intervention?
I mean, that is plaintiff's argument that they terminated the lease. We would say that if they did terminate the lease, defendant is now a holdover tenant. And if they did not, then they needed to provide the notice pursuant to the lease.
Is that indeed plaintiff's position that the lease was terminated?
Yes, Your Honor, under the
So-
way that, but it's specific to, there's a distinction between whether we're filing under 1C1 versus 1C3. We filed under 1C1, which is under the power to terminate. What defendants are arguing is that it should be under, what they're saying is that the lease is terminated, and then therefore it should be treated as a sufferance matter under 1C3.
Well, I mean, in bottom line, what they're saying is if one believes that the lease is terminated, so the lease no longer exists, they become a holdover, which in that case, they'd have to get 30 days notice, which means I don't have jurisdiction.
Your Honor, if I may, it is defendant's position that the lease was not properly terminated. So just to clarify for the record, we do not believe that the lease was properly terminated. However, following plaintiff's argument that they terminated the lease on April 23rd, effective April 23rd, 2026, that would then render defendant a holdover tenant, creating an estate at sufferance, requiring 30-day notice before this court could have jurisdiction.
Okay. Go ahead.
Your Honor, to the extent that this court finds that the lease was not terminated and would permit the court to permit plaintiff to proceed under section C1, plaintiff relies on the Michigan Landlord Tenant Handbook, which explains that a power to terminate in the lease must specify the notice of termination to which plaintiff is entitled. Here, the lease does not provide any notice period. It just provides that notice that the landlord must provide notice to terminate. A standard notice in this circumstance would be where rent is paid on a monthly basis would be 1 month's notice. Here, no notice was provided. As plaintiff pointed out, they filed their notice. They sent the notice of termination on the same day that they filed this complaint. Moving to the second point, if this court does find that notice was provided, defendant still ask this court to find that plaintiff waived its right to terminate the lease based on its acceptance of rent following both the date on which they purport to have terminated the lease, the date on which they sent notice of the purported termination, the date on which they said they filed their 7-day notice and initiation of this action, and continued to the present. They have continued to accept rent. As discussed in our prior hearing, the fact that the lease contains certain landlord favorable self-help remedies does not necessarily mean that the landlord is entitled to those remedies. As Your Honor knows, leases regularly contain language that is unenforceable under the law, and the law governs what a landlord may or may not do. So the fact that a self-help remedy is written into the contract does not automatically render that provision consistent with the law, even if it is a commercial lease. And just to address the point of this being a commercial lease,
Yes, ma'am.
plaintiff argues that Park Forest should not apply because this is a commercial lease, but has cited no case law directly addressing that point.
I don't really need much argument on that.
Okay.
Court has consistently held that Park Forest as a principle applies, so. And
Excellent.
I wouldn't see any reason why I would change that position.
Just to briefly continue, plaintiff also argues in its brief that dismissal here would be an unduly harsh remedy. It's unclear how that would be the case. Plaintiff agreed to rent this property to defendant for the term in the lease. Defendant has made and continues to make every effort to remain in the property. Despite defendant disputing the amount of late fees owed, is paid over $32,000 in late fees to date to avoid a possession judgment. So it's unclear how a harsh remedy would result if Your Honor were to find that there is no jurisdiction. And finally, if this court does find that there is jurisdiction to hear these summary proceedings, we would assert that termination of the lease was improper because based on the amount of late fees and based on the allegations about improperly stocking the premises and maintaining the inventory.
The inventory issue, has their client cured
Your
or
Honor,
not?
defendant disputes that there is any inventory issue.
Got it. So the issue that's raised, you're saying doesn't really exist as a basis for termination because it doesn't exist.
Exactly. And we've, at this point, paid the late fees. Plaintiff has now provided that our additional late owed. As Your Honor is aware, there's been continuing developments about the amount of late fees apportioned to each property and providing proper accounting of those fees.
And Your Honor, I can address that particularly.
Go ahead.
Specifically on apportionment, the defendant, these leases, so this lease plus a lease in Ann Arbor plus a lease in Ludington, all arise from an asset purchase agreement involving the defendant. They have habitually paid the payment as a batch on the same exact day. So when one is late, they all are late. And so when we were originally sending notices to the tenants for each of the properties, that's why it was a collective number. But so for example, when defendants were late on June 1st, we reference a 2,737. It's apportioned easily by 10% of that monthly fee for the particular tenant at issue. Here, the rent is a little over $10,000. That's how you get to a $1,000 late fee remaining for June for that tenant.
I do have one question. There are currently 3 different myself and 2 other district courts dealing with.
And a circuit court dealing with the license dispute.
Shouldn't I'll go to the circuit court? No, I just say that on behalf of my district court judges. But why couldn't there be on all of these issues absolutely inconsistent rulings?
The Ludington judge also acknowledged that issue, but the concern is that the ability to terminate the leases are separate from the license ability, and the jurisdiction for that issue for each lease remains with that court where the property sits. Unless I suppose the parties could have reached an agreement.
Well, I don't.
That issue, but.
Well, for the district court, which circuit court is?
Washtenaw County Circuit Court for the licensing dispute.
Do you know which judge has it?
Judge Kunke.
Oh, I'm sure she'd love to have all of these. No.
Dealt with the asset purchase dispute as well 2 years ago.
So, I would expect, so the way the court rule reads with reference to summary proceedings, it just doesn't come up much, but that the action has to be held at proper venue, and it has to be heard in that venue. It being, part of my thought is that it being a venue issue, I'm not sure when one begins to give an analysis to what may be a proper venue or a convenient venue, that the parties could not stipulate to venue resting in one spot. Now, I'll be honest with you, I'm not sure of that, because since the rule regarding venue changed with 2017 during the pandemic, that the Supreme Court issued, well, those things that made a lot of district court judges' lives miserable. And specifically the venue issue. So it's easy when in a jurisdiction like Washtenaw County, where as a 14A judge, I border 14B as well as 15th, that we just have to send it. If you're on the wrong side of the road and you filed it, we get why you did that, but we just send it. This seems to me to be a more difficult issue, because I don't know for either side, quite frankly, what having potentially inconsistent rulings would do. I mean, is everybody in agreement with that, at least?
100% in agreement with it. And I'm willing to discuss with defendants about the potential to consolidate. It's just been a matter of really.
Yeah, I'm sure Ann Arbor and Ludington would love to have this case. No, I'm kidding. But I don't think any of the judges would, by any means, if the parties were able to agree. I don't think anybody's going to feel bad. Nobody's going to. It's just, it doesn't make much sense. And you're going to be making the same arguments, presumably in 3 different courts, right?
Streamline discovery, because the other two lease matters are now in the discovery period.
Your Honor, if I may, to plaintiff's point, these cases are now all in different stages of litigation, and they're all separate properties. So it could be the case that one court finds that one lease was that possession judgment is proper, where it's not in another property.
Okay.
These are all distinct stores.
I would say, though, however, the license dispute covers all 3 businesses. So that's the one in front of Judge Kunke. That actually underlies the issue of inventory across all 3 stores. So when we talk about, and I disagree, other than whatever your Honor decides today, as if we proceed to discovery or if it dismisses or something else, the other 2 cases are in discovery. One set 10 discovery September 13, I believe, or September 17, and the one following 2 weeks later. So, and no discovery has actually been taken. So there's procedurally for the other 2 leases, we are actually in the exact same spot.
But I think the defendant's making a bigger point, and that is, which I'm not going to disagree with. Why would I take a chance of one ruling and losing 3 things when I may be able in some way, even if legally and factually I'm having an issue, that my client may be able to salvage 1. I'll put it that way. And I'm not saying that in a bad way. I just hadn't thought about it from that perspective. So, all right. If you can agree on it, you can agree on it or not. It doesn't really, either way. I'll be here. I'll hear it. So I'm ready to rule on the issue of jurisdiction of that. I always think that when court when parties act in a way to try to invoke the subject matter jurisdiction of particularly the district court, the statutory court, the real question in the court's mind is, has the individual or has the party done enough that, while not technically right, has indeed invoked the jurisdiction of the court? I think jurisdiction fails where it's clear that the party has not. I believe that the court does have jurisdiction to hear the termination action. I've already ruled on the non-payment of rent action because that one is different. But I believe that the court has subject matter jurisdiction to hear the termination issue. And so I will do so. Thank you for your yes.
That we be granted 6 weeks for discovery on this issue.
On the case.
No objection to that, Your Honor.
6 weeks. Where does that put me in? That's going to put me near the end of September. Is that what you think?
Yes, Your Honor.
I will grant discovery in the case, because typically in my landlord tenants or summary proceedings, there's no discovery. But I will grant discovery. Let me ask you this, folks. Are you intending on taking depositions or not? Because my discovery does not permit typically.
We are intending to take that position.
Of course you are. Okay, here's what I'm going to do. I'm going to trust that the parties will behave themselves, and I will just allow discovery until September 30th, just to close by that point in time. All right. If there are any issues, the way I also operate, if there are any issues with discovery that the parties can't resolve, rather than try to extend something or fight with each other or file a motion, you can contact my office. I may set a Zoom between you and just try to resolve whatever that issue is. All right. I don't like a lot of formal motions on discovery. I will then set a final set. Yeah, we're going to give one Tuesday after September 30th.
October 6th.
All right. I'll set a final. Well, I'll just call it a settlement conference for October 6th, 2026, 9 a.m. in person. And just so that you folks are aware, I won't be in my courtroom. This one, I will be in courtroom A on that. Okay.
Thank you very much.
Thank you, folks. All right. We got to get to the